So kind of next, what the statute says burden of proof in it. What does that mean? And I kind of we'll start back with Marshall, but what is the burden of proof in a post-decree custody case, and who has the obligation to meet that burden?
Well, if you're looking at burdens of proof in classical legal theory, you get two pieces to it. One is the burden of going forward, and the second is the burden of persuasion. So the first aspect of a burden of proof is who's got to prove something. If nobody shows up, what happens? And the answer is, well, if nobody shows up, whoever's got the burden of proof loses, because they didn't show up to present anything. So somebody's got to go forward. The rest of the burden of proof is what happens if you're at 50-50. Does somebody have to reach preponderance? And that seems to be where the appellate courts are going for pretty much every issue where there's an undefined standard. Now, what does preponderance mean? For those who are not legal scholars out there, there is a whole range of standards of proof that you have to satisfy. At one end, as Michael was talking about with criminal law, it's beyond a reasonable doubt. We're dealing with the most serious, highest conviction standard. At the other end, we're dealing with like a traffic stop, reasonable, articulable suspicion, right? Well, preponderance is somewhere in between. Think of it as 50% plus one. We're almost at a tie, but yeah, we'll give you that extra point. And if you're there, that's the burden of proof for most standards. If you're at clear and convincing for those statutes that require clear and convincing evidence, like domestic violence, then it's somewhere between preponderance and beyond a reasonable doubt. Where exactly? The courts are never going to define it in such a way that limits their discretion. So all you can do is put them in order and tell them that they're in increasing order of severity. But no lawyer could or really should try to exactly define these terms, because it's going to be highly individual with the individual case. If my colleagues here feel differently, feel free to chime in with your own definition. But I'm unable to I have had clients, give it to me in math. Are we doing 41%, 47%? And I can't do that. I'm sorry. I can't, because the courts won't. If they would, then I would be happy to repeat it to you. But you're asking me to just make stuff up, and I don't like doing that.
Well, and I think in the context of a custody case, the burden of proof exists. It's in the law that the moving party, bears the burden to prove their case, both prima facie in the initial motion and then preponderance at the hearing, unless it requires clear and convincing on those special factors. But at the end of the day, we're talking about children, and we're talking about human beings, and the courts are going to consider the facts and make its decision based upon really what's in the best interest of the children at the end of the day. But I think it's important just to include, to know, hey, if you're going to bring this motion, you have to have something. You can't just bring it because you feel like you want it to change. And that's kind of where I was wanting to go with that.
Can I expand on that just a little bit too? I want to just circle back. I agree a lot with Marshall's, I'll know it when I'll see it example. And I think that's really important for people to understand. And what you just said too, Andrea, that you can't just go into court and say, I want to change it because I want to change it. You have to have a reason. But I think it's important for people to know that we don't have a list of what will get you a change in custody. We don't have a list of what meets that burden. And so to the extent possible, and I know that, again, 50% of our litigants are unrepresented. To the extent possible, though, that if those litigants, who obviously we're trying to reach today, can have a consultation with a lawyer, can go to Ask the Lawyer program, something like that, because it's hard for us to give a complete picture today. It's impossible for us to give a complete picture of what to do and when to do it, because we don't even know, because it's not laid out very clear.